Okay, we'll start in 1 minute. All right, it's 10:25. Good morning, everyone. Can everyone hear me? Just nod if you can hear me. Yeah, okay. So next week is the last week of classes, and so thoughts turn towards the exam. I'll give you more details about the exam next week. And also after class is over, I'm going to set up additional review session, at least one, for if you have any questions or you want to work through a hypo with me. And I will also probably, I've done this in the past, set up a discussion board on Canvas so everyone who has questions can just ask them. I will stop receiving questions a day or two before the exam starts. But if you're starting to feel worried about the exam, don't worry. There's going to be lots of opportunity to recap, to do questions. But you should be outlining and reviewing now or soon. I have office hours this afternoon. Remember, there's group office hours, which can be just drop in. I will make sure that all the slides are up on Canvas are corrected. Sometimes I make, as you know, small mistakes in the slides for class. So everything that will be put on Canvas will be correct. So if there's any difference between the slides you download from my emails and the Canvas slides, you should go with the Canvas slides. I think that is it. Okay, on the call today, Jack, Abigail, Tyler, Priya, Alex, and Aaron. All right, so yesterday we started talking about the law of self-defense, and in particular, the rules governing the use of deadly force in self-defense. And remember, deadly force is understood a little bit, it's not just force that results in death, but force that poses a high risk of death or substantial bodily injury. Now, we learned that in the common law, and this is a little bit refined or simplified from yesterday, we learned that the defendant is justified in using force when they subjectively believe it is necessary to protect against the imminent use of unlawful and deadly force against them. And remember here again, deadly force is force that can kill you or that can cause serious bodily injury. And it is objectively reasonable for the defendant to have believed that. As we talked about yesterday, in many, many states, they have statutorily expanded upon the very narrow common law rules to include a whole set of predicate offenses or predicate threats that are considered equal for purposes of the use of the justification with the threat of unlawful and deadly force. Everything else stays the same, however. And then we learned that under the MPC, the rule is a bit more complicated because here the test is subjective belief that deadly force is necessary or that it's necessary to prevent one of the very few predicate threats. But the belief need not be objectively reasonable. However, if you're reckless or negligent in possessing the belief that the force is necessary, you can be prosecuted for crimes with a mens rea of negligence or recklessness. So while the common law provides a kind of on-off switch to culpability, you either have the self-defense and that fully exculpates you or you don't. In the MPC, it's much more of a grading system where you can still be held liable, but it is for a lesser crime. But this is assuming that the lesser crime exists. So we know that with homicide, we have crimes going all the way up and down the mens rea hierarchy. With other crimes, that may not be the case. And so if the prosecution does not have available to it a negligence or a recklessness crime, then you are fully exculpated. It depends to some degree upon the details of the statutory scheme. Now, we're going to return for a few minutes to the discussion we ended class with yesterday, which is about how do we think about the imminence requirement and what do we make of the reform to imminence that the MPC enacted. But I just want to make two other things clear that we didn't discuss, but that it's important for you to know. So the first is that the same rules apply when force is used to protect another, okay? We learned the justification for self-defense, but it is exactly the same as the justification for defense of others. So the common law justification for use of deadly force in defense of others, it's just that the threat isn't against you, it's against another. but the similar constraints, same constraints apply. The force must be necessary to protect the other against that force. It must be an imminent threat of force, and your belief about the necessity of that force must have been objectively reasonable. And, it's the same in New York. You just add on the threat should be to another, and the same thing in the MPC. So we learned not one defense yesterday, but we learned two defenses. And then the similar rules, but a little bit altered, apply for those who don't use deadly force, who use non-deadly force against another, force that doesn't pose a high risk of death or serious bodily injury. And in these cases, the proportionality analysis is a little bit different. You ask, so the defendant, similarly to the use of deadly force, the defendant must have believed that that force was necessary to prevent imminent harm to herself. The imminence requirement applies, and there is a necessity principle. But the jury is asked to assess on its own terms both the reasonableness of the defendant's belief about the necessity of force and the reasonableness of the amount of force used. So the jury just goes through its own analysis of the reasonableness of the amount of force. It is tasked with the job of assessing proportionality pretty directly. And the same thing is true in the MPC. The defendant must believe the force is necessary. And then the question is, was the belief about both the necessity of the force and the amount of force, was it objectively reasonable, or was it reckless or negligent, in which case you can be held liable for a recklessness or negligence crime. Okay. Now, so that's the law of self-defense so far that we've learned in a nutshell. And as we talked about yesterday, there are obvious and serious problems with it. So on the one hand, because it relies ultimately, at least in common law jurisdictions, on a jury's determination of when force is objectively reasonable, and even in MPC jurisdictions, it relies upon a jury's view of when a belief that isn't even objectively reasonable is still a gross deviation from the standard of ordinary care, right? There's a kind of implicit view of social norms, even in the MPC approach. It allows the jury to rely upon stereotypes or racist beliefs when assessing what kinds of actions by some private persons against other private persons pose a serious threat of harm, right? This is the jury assessing when it is permissible within the supposedly peaceful sphere of civil society for one individual to use force against another. Now, this is not unique to the law of self-defense. We talked about similar problems with jury bias and racism when it came to the law of rape. Right? You might think juries are similarly problematic instruments for assessing when someone is acting unreasonably and having non-consensual sexual intercourse with another. But the open-ended nature of the objective reasonableness judgment, and I also think the fact that what we are doing here is we are giving state sanction to some private individual's use of deadly force against another without due process of law, without any judicial process, without any safeguards, and makes it uniquely or particularly problematic when it comes to the law of self-defense. And the Getz case is infamous, I think, for really posing this problem very starkly. On the other hand, because the common law allows the justification only in cases of imminent threat, it limits the ability of certain kinds of people, right, those who fear harm that may be inevitable but may not be imminent, to take advantage of the justification. So in some ways, we might think it's just too broad. It gives too much government permission for the use of private violence against others. And in other contexts, we might worry that it's not broad enough, that it places individuals who are faced with certain forms of threat and harm in a terrible situation where they don't have the justification and they have to choose between being willing to go to jail or facing what might be very serious harm. And we saw this when we talked about the State v. Schroeder and the Harvey State cases. So this is on 912 and 913. So the first one is the inmate who stabs his cellmate in the middle of the night while sleeping, right? And this was, the cellmate had a reputation for forcing other prisoners to have sex with him, for raping him. And the defendant was in debt to the victim, and had been told that the debt might be collected that night. And so he's lying in his bed, extremely worried. I mean, by all accounts, terrified that there's this terrible use of force is going to be used against him. But the court held that there was no imminence because the victim of his assault was sleeping. and said that there's just a very real danger in a rule which would legalize preventive assaults involving the use of deadly force where there has been nothing more than threats, right? There's this real anxiety about authorizing prophylactic violence. And then in Harvey State, similarly, and I think I have a quote, it's a very interesting case, right? The court said, we agree that there was sufficient evidence that a reasonable person in Ha's position, this is the defendant, would have feared death or serious physical injury from the victim, who was Boo, who had a reputation of significant violence. Boo had threatened him with death. Boo was a violent man who nursed grudges and was likely to carry out his threats someday. He came from a violent criminal clan. And the defense attorney had provided quite a lot of evidence that Ha believed, and there was evidence to support the belief that he would be subject to retaliation from from Boo or his family soon. But the court held that inevitable harm is not the same as imminent harm. And even though Ha may have reasonably feared that Boo or one of his relatives would someday kill him, a reasonable fear of future harm, okay, so it satisfies all the other requirements of the law of self-defense, does not authorize a person to hunt down and kill an enemy. Okay, here again, there is this real worry about authorizing prophylactic violence. And so I'm curious, I'm going to poll the class. I want to know normatively, this isn't about the law, but this is normatively, what do you think should be the rule? Should the defendant and Schroeder have been able to get the self-defense justification? That's the prison case. And should Ha been able to get the justification? So we'll do one. Okay, so 60% of you say Schroeder should have been able to, and 41% of you say no. And I'm sorry, I should have made this one poll, but let's now just do Ha. This is very interesting. Okay, very different results. So in the second case, 31% of you think he should have been able to get the justification, and 70% of you think no. So the class reversed, the proportions reversed. Okay, so I want to hear, for those of you who voted differently in the two different cases, why? Why do these require or result in different normative judgments? Miriam.
Yeah, so I said yes in the case of Schroeder and no in the case of Ha. And to me, it comes down to a question of just how many other options you have, right? If you are in prison, truly there's so few other options that, to me, that's conceptually close to this issue of imminence. Whereas even though this person is frightening in Ha, it's, in theory, it's more possible that Ha would be able to get other kinds of help, might be able to call the police, might be able to take more preventive measures, and so it's less necessary to resort to force.
Mm-hmm. So this is kind of an objective analysis of necessity, and imminence, just in different situations, imminence is a better or less good proxy for necessity. Is that what I'm hearing you say? Yeah. Dylan?
So I voted the exact opposite of Miriam, and I did so because I think that in the Ha case, there's already been an attempt on his life. Boo had already tried to kill him, which I think provides more of a necessity justification, and also all of the evidence that like death was actually inevitably coming, like Boo was going to hunt him down and try to kill him. Combined with the fact that Ha didn't think that the police would help him because he couldn't speak English well enough to generate their help, makes a pretty compelling case for like why he would have objectively perceived that he needed to use lethal force in self-defense. Whereas in Schroeder, like, maybe he can't run away or go to the police, but there are presumably prison guards and stuff like that. So I think I find that a little bit less persuasive.
It's interesting that both Miriam and Dylan's comments suggest that what's driving your normative analysis is not really a focus on imminence per se, but about the availability of alternatives, right? Can you go to the prison guards? Can you go to the police or not? And this is the kind of argument that reformers have argued. We should allow juries to assess much more directly, that there should just be a free-floating necessity analysis in the part of the sort of jury analysis of the self-defense rather than relying upon the proxy of imminence. Now, the MPC was clearly receptive to the criticisms of the imminence requirement as it had been understood at common law, and as we talked about yesterday, as it had been understood to mean a very narrow scope of time. Okay, the common law courts never defined it. They didn't say 5 minutes, but it's short enough time that you really have no ability to do anything other than respond violently. And so the MPC changed the rules to require it that the force not be imminent but be immediate, and that force be necessary on the present occasion. And so the MPC commentaries explained that you need not apprehend that the force will be used immediately, but it must be used on the present occasion. So it would be a privilege to use defensive force to prevent an assailant from going to summon reinforcements, given a belief that it is necessary to disable him to prevent an attack by overwhelming numbers, so long as the attack is apprehended on the present occasion. And quite explicitly, the MPC is not defining present occasion. This is one of the many instances in which it is leaving up to the jury to figure out what that means so that we can have the attainment of a just result in cases of this kind. So now I'm going to ask you doctrinally, what do you think? Under the MPC, what should be the results? All right, we've been proceeding under the assumption in these cases that it's the common law applying. Would the defendant in Schroeder be able to get the justification under the MPC? Would the defendant in Ha? And would the defendant in Sands, right? That's the domestic violence case we talked about yesterday, where the defendant killed her husband while he was watching television after a day of really horrific abuse, and she believes he's going to hurt her the next day. Okay, vote. All right, I'm going to end the poll in 5, 4, 3, 2. Aaron says he doesn't see a poll, but I don't know, Aaron, what's going on. Okay, so really mixed results. It's interesting. So 65% of you think that the defendant in Schroeder would have been able to get the justification. 27% of you think Ha, and Sands, 60% say yes. Okay. Someone explain why Schroeder. Those who voted yes in Schroeder. Put up your hand. Well, let's check. Avery.
My reasoning in Schroeder was kind of like my reasoning in the third domestic violence case. Mm-hmm. I sort of thought about it spatially, where the two parties were sort of trapped in a situation together. Mm-hmm. And the party who was fearing violence did not have an opportunity to get out of the situation. And so for me, that kind of made it the same ongoing situation with the same dynamic between the two parties.
So does that mean that in both Schroeder and Sands, as long as they're in the same place, the present occasion continues? Like, what's the limit of present occasion?
For me, it's more that they're in the same place and they don't have an opportunity to change that between the present fear and when they think the violence is going to occur. Mm-hmm. So, like, if you were in a situation but you had an opportunity to get out and remove yourself from that person, I think that might be a little different.
Okay, and people who said no, why no in Schroeder, say? And perhaps the same applies in Sands. Julian.
So I said no in both of them because they seem like cases where it's not immediately necessary because it's such a prolonged event. It seems like it could have been an hour later that there could have been self-defense, and so it's not at no single point was it immediately necessary.
Yeah, in fact, although the case book is really not clear, Schroeder is an MPC case. Okay, Schroeder was decided under the MPC principles, and the majority basically holds that this isn't the present occasion for along similar lines as Julian suggested, that because the present occasion is maybe the sleeping occasion, and then when they wake up, it's a new occasion. And then the dissent, of course, disagrees on this point. The dissent thinks along the lines of what Avery was suggested, that this is all part of the present occasion, and therefore self-defense is authorized. What about in Ha? Why is Ha different? Someone want to explain who voted that the defendant in Schroeder or Sands would have been able to get the justification, but the defendant in Ha would not? Why is Ha different? Daniel.
Yeah, to me, I thought the difference was that there's a sort of break in the action in Ha. Like, Booth says, okay, I'm going to come back, and, like, you're in trouble, basically. Which, to me, kind of... let me go back to the language. But basically, it ended sort of the present event, and the further threat would have been in kind of a future event. So it becomes more in kind of the color of anticipation rather than a kind of present threat.
Yeah. So we can see that there are all kinds of judgments about what counts as an occasion. Does it involve, is it a occasion? Is sleeping an occasion and waking an occasion? Is it being in the same location? All one occasion is the fact that in the Ha case, it was the next day, right, late in the afternoon, that he goes and pursues the victim, that makes it a different occasion. The MPC provides no help along this way. And the result has been that courts that apply it either define it to mean basically imminence, as in the case of Schroeder, where they just won't even allow the jury to make it, to figure out what that means, or they just hand it to the jury. And it's up to whatever the jury makes of this language, present occasion, to figure it out. For your purposes as a lawyer, if you're arguing within an MPC jurisdiction, it gives you more room to argue. Now, it's not obvious to me how successful it will be or how significant as an empirical matter it is as a change. And one might think that, if the concern that the MPC was responding to was this real worry that imminence is, that there will be cases in which even when violence is not imminent, it is inevitable because the defendant has no resources. One might wonder whether this change in language is actually a satisfactory response to that, right, given how whatever juries may make of it, and the ability, of course, to read immediate to mean just imminent. But you can also see in the narrowness of the reform that the MPC enacted a real concern about authorizing too much use of violence prophylactically. And so I'm willing to significantly depart from the ordinary rules when it comes to the MPC. Okay, so those are the rules so far. That finishes basically the recap from yesterday. Does anyone have any questions about what we've talked about so far? Emma.
I guess it just strikes me that in all three of these cases, there was a real concern about the ability of law enforcement or official actors to be able to intervene, not only because of the temporal horizon, but also because of other impediments such as their social position. And I guess I'm just wondering how and if courts explicitly deal with that, because it feels a little bit strange that you probably don't necessarily want courts to say it's fine for people to completely have no trust and opt out from going to law enforcement, but it also seems like a very valid position for the defendants to believe in these situations. From my perspective.
Great question. I mean, it is a huge issue underlying, and I think that can help explain a lot of the turmoil underlying self-defense. As we're going to talk about very soon, there's been really tremendous change in the law of self-defense over the last century. Courts and jurisdictions, legislatures in particular, keep changing how they define self-defense. And in part, I think it is because of a distrust or skepticism about the availability of the police and the institutional apparatus of the state to protect individuals against private violence. And so a willingness to empower more private violence in response to a threat. And so one can understand the stand your ground laws, which we're going to talk about very soon, as a response to that concern. Now, when we get there, we should think about how effective they are in, say, the Sands case in protecting against victims of domestic violence. Who are they authorizing? How are they going to be mobilized? But yes, on the one hand, from the judicial perspective, I think there's been a real concern, real unwillingness to expand the defense too much because, private violence is not a good thing. We don't want to allow people to just go around killing each other. And I think courts really want to just push the state to be better at providing help to people who are threatened. But from the legislative perspective, there has been and continues to be significant pressure to expand the law of self-defense, in part because of a disbelief that the police will be available. So, yes, I think that underpins a lot of what we're about to talk about. So that's a great segue to this question about the duty to retreat. Okay, so as we now know, imminence is a major restriction on the availability of the defense. But besides from imminence, there is another very important limit, well, two more that we're going to talk about today. And the first is the duty to retreat. Now, the duty to retreat is a very old duty that has been read into the law of self-defense. At common law, right, there was no duty to retreat for individuals who wanted to justify the use of non-deadly force in self-defense. So if you wanted to just rough someone up or punch them on the shoulder, you had no duty to retreat. But everyone had a duty to retreat when using deadly force in self-defense. And in England, at common law, courts applied this duty very strictly. The idea was that the duty flowed from the principle of necessity. If one could avoid the use of deadly force, if one could preserve life by simply leaving the situation, there was therefore no necessity for self-defense and no justification. Okay, so Jack, put up your hand.
Yeah.
All right, so if one man tried to have a fight with another and the other one punched him in the face, there was no requirement that that other man figure out whether he can retreat. But if someone threatens you with a sword, you are not authorized to respond in kind if it turns out you could have gotten away. Now, why do you think courts drew this distinction between deadly force and non-deadly force? Why not just say everyone has a duty to retreat, let's minimize violence altogether?
Because I guess they see taking of a life as way further than just allowing somebody to fight to defend themselves.
Okay, sure. But still, I mean, if we were, say, pacifistic, we might say everyone has a duty to retreat. If you can retreat, retreat. I mean, that is what I would tell my children, right? If someone tries to fight with you, run away. And I'm not going to ask them to assess whether it's deadly or non-deadly. It's just violence is a bad thing. So why might common law courts have held quite explicitly that there is just no duty to retreat when using non-deadly force?
Maybe like cultural conceptions of honor.
Great. Say more. That's right.
I guess when challenged or attacked, you have maybe even an expectation to fight back instead of just running away. It's cowardice.
Yeah. Cowardice, I think, plays a really important role in shaping the limits of the law or the use of the law of self-defense. Here we see, even in the common law, which has the sort of very strict conception of the duty to retreat, the necessity principle sidelined by the powerful cultural intuition that people, and I think particularly men, both will and should be allowed to defend against threats to their person when they don't rise to the level where it's likely that someone is going to die. And I think, Jack, you're completely correct. Underlying this is a desire not to create, as one court said, a country of cowards. Okay, there is this explicit, remember the criminal law is doing all kinds of things, but one of the things it's doing is it's expressing underlying social norms and moral beliefs. And so the courts were very wary of expressing a norm that men should be cowards. Now, as the casebook makes clear, in the 19th century, American courts began to adopt this reasoning to hold that there was no duty to retreat, even in cases involving deadly force. Okay. And this became known as the True Man Doctrine. And really, I always think of Clint Eastwood when I think about the True Man Doctrine. A true man, and this is language from Irwin v. State from the Ohio Supreme Court, has no obligation to retreat when faced with an unlawful aggressor. Now, we're going to talk about what it means for someone to be an unlawful aggressor in a few moments. But Jack, why might courts in America in the 19th century, say, during a time of westward expansion, maybe a limited state capacity, have expanded limited the duty of retreat, rejected the duty of retreat, even in cases involving deadly force?
I mean, there's definitely like a self-image at the time of like America as plucky self-starters, rugged individualists, and I think that probably has a lot to do with it. But as you were getting at, like if they're expanding westward, the actual reach of the state is not as strong.
Mm-hmm.
So.
Yeah, I mean, there's both, I think, ideology of cowardice here, but there's also an idea of deterrence, that the best way to prevent private violence in a context in which maybe there is limited state capacity, there's no police, for example, through much of the 19th century, there's limited sheriffs. In many places, you're far away from anything we would think of as sort of protective forces of the state. The best way of preventing people from using deadly force against you is to make it clear to everyone that if you're going to try and start someone with someone else, you could be the recipient of equal force, right? So the court in the highest Supreme Court, the rule announced is the surest way to prevent the occurrence of occasions for taking life, and this by letting the would-be robber, murderer, ravisher, and such like know that their lives are in a measure in the hands of their intended victims. There's a way of thinking about this is we're going to deputize all private citizens. When they're the recipient of unlawful violence, they can use violence, right? They don't need to go to the police. They don't have to retreat. They can use it to deter and enforce the rule against this kind of unlawful violence. Now, this argument was incredibly successful through much of the 19th century. So by the end of the 19th century, the duty of retreat had basically been vanquished in almost all of the states and territories in the U.S. But beginning in the 20th century, and maybe in response to, I don't want to be too deterministic about this, but with the emergence of the modern police force and the expansion of the welfare state and the rise in state capacity, we're no longer in the Wild West, exactly, right? There comes the reemergence of the idea that necessity should trump manliness, at least some of the time. And so in many jurisdictions, courts once again embrace the idea that a defendant has a duty to retreat from the scene of a potentially deadly confrontation, at least when it is reasonably possible to do so. Now, at common law, it had been something like a strict liability rule. If the court thinks it is available, the duty, if you can retreat, you have to. Here, we're gonna mediate it through a reasonableness inquiry. The jury is asked, would it have been reasonable for the defendant to retreat? Another way of saying this is the defendant was required to use all reasonable means of escape to avoid having to use deadly force, but not unreasonable means. And so it's a somewhat more limited duty of retreat than a common law, but it's still powerful. Now, acceptance of the duty to retreat wasn't universal, however, and courts remained quite controversial. Ale, do you have a question?
Yeah, I just have a clarifying question. When we say no duty to retreat when using non-deadly force, is it when the aggressor is using non-deadly force or when you are using non-deadly force in response?
When you are invoking the justification for the use of non-deadly force. Okay, remember, whether your force is classified as deadly or non-deadly will alter there's a separate justification for the use of deadly force in self-defense or the use of non-deadly force in self-defense. So in non-deadly force cases where you yourself used non-deadly force, no duty to retreat. But if you're trying to get a justification for the use of force that carries with it a risk of death or serious bodily injury, you have a duty to retreat. Of course, in some ways, it doesn't matter whose force because it's all supposed to be proportional. But just technically, when thinking about how to frame it, it's you, the defendant, what kind of justification are you arguing? That determines whether or not you have a duty to retreat. Alex.
Just sort of similar to Ali's question, the reasonable sentence just reads somewhat ambiguously to me. So do you mind breaking it down a little bit more for me, just in terms of where the reasonability is? Is it with the retreating? Is it with the violence?
Oh, I'm sorry. Yes, everyone has a duty to retreat rather than use deadly force. And that, again, means force that creates a high risk of death or serious bodily injury. It's not just force that results in death. Everyone has a duty to retreat when it is reasonably possible to retreat. Okay, and we're going to have an objective reasonableness standard. It's not going to be about subjective beliefs. Of course, the defendant has to subjectively believe that force is necessary, but the jury is going to make an independent determination about whether it was objectively reasonable for the defendant to have retreated or not. Okay? And actually, that's a great segue to my last question for Jack, which is, okay, leaving aside the question about, does this promote cowardice or manliness or whatever conception of the correct behavior of the individual when faced with violence should be, are there any other problems with an objective reasonableness test of retreat? Like you're the victim, someone is coming at you. What might be the problems with requiring imposing a reasonableness duty of retreat?
It's applying a reasonableness standard to someone who is, I guess, ostensibly being attacked. Like they're having to make a snap judgment, and that just might not be fair.
Yeah, I mean, I think it might be the view is that it's quite difficult to expect individuals in this circumstance to be reasonable, right? Someone's coming at you, you don't quite know what's available. Maybe you're going to have a different assessment of the facts than the jury. And so the worry was that this just makes it too difficult. It places too difficult a burden on people who are being, through no fault of their own, being confronted with a deadly force against them. They have to decide, well, what if a jury disagrees with my assessment of my ability to retreat? Do I then face serious criminal penalties for what I'm doing? And so this concern with the defendant's ability to tell when retreat was reasonably available led the MPC to change the common law approach to the duty of retreat in interesting and important ways. So Abigail, can you help me? And I think everyone should put like a marker with the MPC provisions that are on 1280, 1281 and 1282, because we're going to be flipping back and forth a lot. Okay, so under the MPC, and this is 3.04 2B2, when does a defendant have a duty to retreat? This is on the bottom of 1281.
So he has a duty to retreat when he knows that he can retreat and be completely safe.
Okay, great. So under the MPC, the duty to retreat is only when the defendant knows that they can do so with complete safety. And that language is intentional, right? It's not just partial safety, it's complete safety. If you know that while retreating, you're going to stub your toe, now you don't have a duty to retreat. It is only in those cases where you feel completely confident that no harm will befall you, you can just easily get away. The MPC wants to require defendants in those cases to retreat, but in no others, precisely because they don't want to put the burden on the individual when confronted with unlawful force to have to figure out what reasonable is. So they're going to set the duty much, much more narrowly. Okay. Now, juries look, again, this is an objective analysis about whether or not the defendant is correct about their knowledge about being able to retreat with complete safety. But the MPC commentaries explicitly instruct that juries should take into account what they call the attendant excitement that may cloud the defendant's mind at the time. So let's look at State v. Abbott on 919 to see how the MPC retreat rules apply. Okay, Abigail, what happens in that case?
So in that case, let's see. Abbott shared a driveway with the Scaranos.
Yeah.
And he built a doorstop for his garage on the shared driveway. And the son of those neighbors disagreed with his building that doorstop and got into an altercation with Abbott. And it seems like the jury found out or decided that Abbott threw the first punch, but Nicholas was the aggressor in the situation.
And why was Nicholas the son the aggressor?
Probably because he kind of like approached him, even if it was just verbally.
I think the view was, and we'll see, this is classic understanding of aggressor under the common law rules. We'll see with the MPC whether that's correct. But Nicholas starts the fight, I think verbally. Then Nicholas punches him. Then Nicholas gets a hatchet, I think, and comes at Abbott. And then the mom, Mary, follows with a carving knife and a large fork. I mean, the facts are amazing. And then there's this dispute about Abbott wrestles the hatchet away from Nicholas. All the Scoranos end up injured, but Abbott claims he's hurt too, and Abbott's indicted for assault and battery. Okay. Now, the issue here specifically is whether Abbott had a duty to retreat, because New Jersey is a model penal code jurisdiction in this respect. And let's assume that the jury believed the Scoranos' version of the story, which I think it mostly did, that Abbott wrestled the hatchet away from the Scoranos and then attacked them with it. Now, did Abbott have a duty to retreat? What does the court hold?
So I think that he would have a duty to retreat if he planned to use deadly force. And I think that you can say, like, hitting someone with a hatchet is probably deadly force, especially since it resulted in, like, severe head trauma.
Okay, so but it makes clear first, in all these cases, the first thing you have to establish when you're figuring out about whether there's a duty to retreat is there the use of deadly force? Is this the kind of force that rises to the level of deadly force? Because it remains the case in both the MPC and the common law today that there's no duty to retreat in cases not involving deadly force. And it's easy when you're shooting at someone that almost presumptively creates deadly force. A hatchet's a little unclear, but yes, I agree with you. I mean, this looks like deadly force to me when you're hitting someone in the head with a hatchet. And then what's the rule on retreat?
So I think it's the same as the MPC we were just talking about, that you only need to retreat if you know that you can retreat with complete safety.
Yeah, and the court doesn't actually resolve the issue, right? It's just dealing with the jury decision, the underlying the instruction. So let's think about it ourselves. Abigail, what do you think? Did he have a duty to retreat?
Yeah, I think he probably could have just gone into his house and been completely safe from them.
Okay, and what would be and what are the facts that we look at when thinking about the duty to retreat here?
Whether he knew that he could retreat with complete safety. So maybe whether there is a place of complete safety nearby.
And is there?
I mean, his house is right there, so I would think yes.
Okay, so his house is right there. We're on the driveway. Surely he could just run into the house. There's lots of evidence that he's physically more able, and he does have this hatchet. Anyone want to disagree that, in fact, he did not have a duty to retreat? That he didn't know he could retreat with complete safety? Brandon.
He has an entire family attacking him at the moment, and it only takes a split second in order for him to get, mortally wounded with, one of the instruments that the family members had at the time.
Excellent. Yeah, like what instruments? You're speaking very abstractly, but let's flesh it out. What instruments does, for example, the mother have?
She had the machete and then the large fork and carving knife. And
this is a heavily armed family who seem to be working together to protect their son, Nicholas. So I don't know. I actually think the likelihood is that he didn't know that he could retreat with absolute safety because the Scoranos are armed and they're pretty, as Brandon says, pretty seriously armed. Okay, so this is a case when I think, although, again, it is up to the jury, I think there's a very good argument that he did not have a duty to retreat, and therefore the availability of the self-defense justification is a strong one. But what about, Abigail, what about under the common law, if this was a common law jurisdiction? And the question is only, was it reasonably possible for him to retreat?
Under that, I think it is reasonably possible. It seems like his physical strength was a lot strong. I mean, he hurt 3 family members. So even though there were 3 people coming after him, he still came out successful on that. And as I said before, his house was right there. So it seems pretty reasonable.
Yeah, great. I mean, I think Abbott is a good case for illustrating the difference that the MPC and the common law or duty to retreat rules might make. I think under the MPC, it's going to be hard for him to say he did. It's going to be hard for the prosecution to say he did have a duty to retreat. But under the common law, it's much more possible, given his strength that he had. I think he had a hatchet at this time, actually. I think he'd gotten the hatchet from the Scoranos. He could have shown it and then run away, and the house is very close. Now, again, it's not at all crystal clear. The jury ultimately determines whether there was the reasonable possibility of retreat, but it's much easier to conclude under the common law than under the MPC that an individual has a duty to retreat. Now, in part, in response to that, in response to the comparative expansiveness of the duty to retreat in the common law jurisdictions, in many states that applied the common law rules, in the, beginning early 2000s, they began to abolish the duty to retreat sometimes in all cases. And the first and most famous of these laws, and these usually were called stand your ground laws, was enacted in Florida in 2005. Now, the stand your ground law in Florida not only abolished the duty of retreat in cases in which someone uses deadly force in self-defense or in cases where they use deadly force in defense of others, it completely gets rid of the duty to retreat, such that in Florida today, there is no duty to retreat in any self-defense case. You just never have to retreat. The Florida law also provided immunity from arrest or prosecution for anyone who could show at a preliminary hearing by a preponderance of the evidence that they acted in self-defense. And so you don't even get to the prosecution stage in Florida if you can show by 51% of the evidence that you were acting in self-defense. You weren't just preemptive. You weren't just unilaterally attacking. Now, since Florida enacted its law, over 30 states have copied some or all parts of it, although in most states they go somewhat less far than Florida. Many states do not have the preliminary hearing. They don't have the same civil damages immunities. And this is largely as a result of strong legislative action or lobbying by the NRA and by a group called the American Legislative Exchange Council, who argued, and this is along the lines that Emma was suggesting earlier, that police are just not reliable. They don't reliably protect individuals who are threatened by unlawful violence against them. And to require people to put their lives in the hands of perhaps unreliable police officers is to impose too much of a burden on innocent, law-abiding people. And so I think the idea was we're going back to it's something like the Wild West, right? We cannot trust the instruments of the state. They don't provide satisfactory protection. And so we must empower people to take action against those who would harm them. And there is considerable evidence that the stand your ground laws are having impact on case outcomes. Particularly in Florida, in the years since Florida enacted the stand your ground laws, the number of killings that have been deemed to be justified have significantly increased. So defendants are using these justifications, and the number of homicide prosecutions are going down. Now, correlation is not causation. There's lots of different factors going on, but there is evidence these are having a significant effect on the law of self-defense. Now, the stand your ground laws became incredibly controversial in the wake of the shooting of Trayvon Martin by George Zimmerman, and I talked about that briefly yesterday. And I assume everyone in the class has heard of the case, but just to recap, Zimmerman shot the 17-year-old Martin, who was unarmed in what he claimed was self-defense. This was in Florida. And Zimmerman was a member of the Neighborhood Watch, and he began following Martin around his neighborhood because he thought he looked suspicious. This is in his words. And Zimmerman called the cops, and what the cops did was they told him to stop following this teenager. All right, they said, "You're the problem, stop following him." But he claimed that he did, and at that point, Martin charged him. But witnesses provided a contrary story that Zimmerman attacked Martin. Now, Zimmerman was initially not charged with murder because of the stand your ground law. He went through one of these preemptive preliminary hearings and showed by preponderance of the evidence, according to the court, that he was acting in self-defense. But after a public outcry, he was ultimately charged with murder by a special prosecutor who was appointed by the governor. And the necessity of going through the special prosecutor is a sign of sort of the highly unusual and controversial nature of the case. Now, at the time, many people blamed the stand your ground laws for the outcome, for the fact that in the end, Martin was acquitted. And certainly the Florida jury was told in its instructions, and this is part of the instructions in stand your ground states to this day, that Zimmerman had no duty to retreat and had the right to stand his ground and meet force with force. Okay, the language of stand your ground is often a part of the jury instructions in stand your ground states. It's not entirely clear that it was in fact the stand your ground law that ultimately resulted in the acquittal, because Zimmerman's story was that he shot at Martin when Martin was on top of him, bashing his head against the sidewalk. And Abigail, last question for you. I mean, even if we had the common law duty to retreat, if you believe Zimmerman's story that he shot Martin while he was underneath him and his head was being bashed in, did he have a duty to retreat in the common law? What do you think? someone is on top of another person, and that other person, do they have a duty to retreat?
Probably not. It doesn't seem like you can reasonably know that you can get away with complete safety in that situation.
Yeah. I mean, I think ultimately the issue in the case was about the credibility, whose story you believed. And even if the duty of retreat had applied, as it had in Florida up until 2005, if the jury had believed Zimmerman's story, then he would not have had a duty to retreat. On the other hand, if they had believed the prosecution story, that he followed an innocent teenager and then ultimately killed him, he would have been the aggressor, and so he wouldn't have had the self-defense justification at all. So it's, in fact, not entirely clear that it ultimately made a difference in the Trayvon Martin case, although it absolutely made a difference in the procedural history of the case. It initially was the basis for the dismissal of the charges. But in other cases, it clearly makes a difference. So let's look at State v. Smiley on 9/22. Tyler. You put up your hand.
There you go. Can you hear me?
Oh, okay. Yes. All right. So this is the case in which the defendant is a cab driver. He's paid in advance to drive a drunk passenger from a bar. The passenger gets out of the car, but then gets into a fight with the driver and pulls a knife, or allegedly pulls a knife. And then the cab driver draws his gun and shoots him dead. And he was convicted of murder because at the time Florida applied the common law duty of retreat. Now, what would have been the case had he been tried under stand your ground? What do you think?
What do you mean?
Well, in the Smiley case, the court held that he had a duty to retreat because, explain to me. So the court says under the common law rules, where you're not authorized to use deadly force in self-defense if you have a duty to retreat, that he did, in fact, have a duty to retreat that he didn't satisfy, and therefore he was not authorized to invoke the justification. Why did he have a duty to retreat in this case? What do you think?
I think they said that he probably could have got to his car and easily gotten away at this point.
Yeah, I mean, I think he's actually in the car, right? The cab driver's in the car. He's got his hands on the wheel. Surely it was reasonably possible for him to get away. In fact, I think even under the NPC duty to retreat, there's a strong argument that he could have gotten away with complete safety because the assailant or the victim has a knife, but he's in a car, right? Like I think if it had been different, if it had been a gun, because guns can travel far distances, but he could just pump the gas, right, and get out of there. And so under the common law and even under the model penal code, he likely would not have been able to invoke the justification. What about under the stand your ground law? What do you think, Tyler?
He probably could have gotten away with it. I think the stand your ground laws give a lot of deference to the person whose life is being threatened.
Okay, and so what would he have needed to show to get the justification under stand your ground? So there's no duty to retreat, but all the other principles of self-defense still apply. So what does he have to show? I'm actually just pulling up the slide.
Wouldn't it just be that his life was in imminent danger?
Yes, so he has to show his imminent danger of death or serious bodily injury. Oh, sorry.
I think the presence of the knife establishes that.
Yeah, I mean, so I just want to be clear, even in stand your ground laws, it's not as if anytime the defendant invokes self-defense, they automatically get it. They still have to show that deadly force was necessary to prevent an imminent threat of unlawful and deadly force against them and that it was objectively reasonable. But when assessing this, juries do not take into account the possibility that they could have avoided that force by getting away. Okay, the jury is supposed to just take this moment, this encounter on the street in its own terms. And there's just no inquiry about whether or not the fact that he could put his foot on the gas pedal and speed away, that doesn't affect in any way the imminence or the necessity analysis. So what do you think? Was he faced with imminent threat of unlawful and deadly force?
The guy was drunk. So under that pretense, I'd say he's probably a little more rational, a little more emboldened than the average person would be in the situation. Plus the presence of the knife. I probably would have been a little scared. It sounds like his life was in danger, or he could have reasonably believed it was in danger.
Yeah, I mean, there's definitely that you would send it to the jury, and the jury would have had to find that it was objectively reasonable for him to think that his life was in imminent danger. But given the facts, it by no means seems like it's off the table. Mm-hmm. And so stand your ground laws, they work a considerable change to the law of self-defense because prior to the imposition of the stand your ground law, this justification doesn't even go to the jury. Okay, but with stand your ground, it's up to the jury to decide whether or not the use of force was objectively reasonable. Okay, now so stand your ground continues to be, it's now basically the majority approach. 33 states have applied it. Even in jurisdictions that do not have a stand your ground law, the duty of retreat is limited in significant ways, okay, by the Causal Doctrines. So courts do not impose a duty to retreat on those who are threatened in their own homes. And the idea here is that it is unreasonable to allow someone to drive you from your home, your principal space of safety. And the view here is that, I think this emerges out of a period where the outside world is presumed to be extremely dangerous and your refuge is your home. And so there simply makes no sense to require people to retreat in order to reach safety to a place that is, by definition, not really safe. But does this still make sense? So let's look at the hypo in 924. All right. Suppose that a distraught teenager pushes away into the home of a teacher, pulls a knife, cuts the phone lines, and threatens to kill the teacher. If the teacher can easily get to his car and go for help, should he be entitled to ignore that option, pull his gun, and kill the teenager on the spot? What do we think? I did not. I'm curious. What do people think? I didn't make a poll. So raise your hand if you think yes, that the Causal Doctrine should not apply in this scenario.
Professor, to be clear, when you say yes, it should not apply, right?
I understand.
So no to the Causal Doctrine.
No to the Causal Doctrine, that the teacher does have a duty to get in his car and get the hell out of Dodge when threatened by the student. Alex, was that what your question was about? Yeah. Okay. And who thinks no? Put your hands down. Okay. Oh, I didn't know there were buttons for yes and no. That's amazing. Okay, from now on, I'm going to be so sophisticated. All right, I want to hear people who think no. Why no? Well, Tyler, what did you vote, since you're on the hot spot?
I didn't necessarily put my hand up or down because I didn't want to lose my spot at the top. But I could see it from both sides. I think I am a bit... what's the word I'm looking for? Persuaded by the idea of not like what Cardozo says when he says, like, where else would you run in a time of peril other than to your home? Mm-hmm. And so in my mind, I'm like, I feel like if there was ever going to be a place, especially in our society with our individualistic views and like sense of entitlement, I think the home is the one place that I think stand your ground makes the most sense, like the Causal Doctrine.
Yeah, we might think that you never are forced by someone else's unlawful violence out of your house.
Yeah. And
so in this case, even though he could have gotten away, there should be no legal requirement for him to get away. Those who voted the other way, that the duty of retreat should apply, the Causal Doctrine is not appropriate here. Why? Alex?
I think I'm maybe a little bit like a couple standard deviations to the side on my feelings on this, but I just place a high value on human life and think that being at home is completely arbitrary. And if you have a way of escaping, if you don't, it's another matter, perhaps, because there's one life against another life potentially. But if you have the possibility of getting away, like, why does that necessarily entitle someone to kill another person? It just doesn't make sense to me.
Right. So we might think that the principle of protection of human life is the primary goal here. And so there should be a duty to retreat in all cases. But of course, note what that is doing is it's placing more burdens on someone who is the victim or the recipient of unlawful violence. And so the Causal Doctrine is there to provide a kind of protection, even if it results in more bloodshed, in certain circumstances for those who are innocent and are confronted by imminent and unlawful harm. Peter.
Yeah, I largely just agree with Alex's point, but like a small thing to add is we might be worried that these killings are especially a problem in the house because that's where the most guns are. And like without this rule, we might be worried about a lot of deaths just because there's so many guns in America and it might be so easy to kill somebody.
Great, yeah. So we might think that actually the Causal Doctrine is a major exception, a really problematic exception to the duty to retreat. Last comment, Jordan.
Yeah, I totally agree with what everyone else has said. I just wanted to add that I think it has a really interesting interplay with domestic violence, an idea of like, who do we conceive as it being their house? And when does someone have to escape versus like, what can they do within that one place? And when the home becomes not a sanctuary. So I mean, that there as well.
Well, I mean, that's a great segue to the next thing I want to discuss, which is, does the Causal Doctrine apply when the assailant is a co-occupant? A spouse or roommate, or in many cases, a child or roommate, or in many cases, a spouse. So now, here, some states have held that here the duty to retreat does apply, that the Causal Doctrine only applies, the exception from the duty to retreat only applies when it's a stranger or a non-occupant coming into the house. But the vast majority say that the Causal Doctrine still applies, that that you cannot be kicked out of your house by the unlawful violence of another. And here we can think domestic violence situations are the exemplary case. And the defenders of this view have argued that it's really important to empower victims of domestic violence to use violence against the aggressor. And so let's just pick that up when we come back. Let's take a 5-minute break. Let's come back at 11:30. And I'll stick around if people have questions. Matt.
Just to clarify, so with the MPC duty to retreat, does it work the same way as like the subjective reasonably believed that there was imminent danger requirements? Like if you subjectively believe that you couldn't get away, but objectively it seems obvious that you could, would you then just be charged with like a recklessness crime?
Yes. So the MPC is careful to phrase it as about knowledge. You must know that you can retreat from complete safety. And then 3.09 says that if your beliefs about the necessity of violence are reckless or negligent, and I think that speaks to all aspects of your beliefs, then you are charged with a lesser included crime, if it exists. Yes.
Thank you.
Sure. Spencer.
Thanks. I was just wondering, when we talk about common law, the common law duty to retreat, it seems like we were saying, so 19th century it was no duty to retreat, and then 20th century it was there was a duty to retreat. I guess I'm just trying to get straight what the common law rule we should apply is. Yeah,
the historical evolution was just to give some context to the current framework, which has a minority rule, which is that there is a duty to retreat when faced with deadly violence or when using deadly violence, except when the Causal Doctrine and these other exceptions apply. But then in stand your ground states, they're applying basically the 19th century approach, where there's just no duty to retreat. And so we actually have a mix of those two approaches. Either stand your ground law is no duty to retreat, non-stand your ground law states like Illinois, there is a duty to retreat, but only when the Causal Doctrine doesn't apply.
Got it. And reasonably possible is the common law.
That's right.
Reasonably possible. Okay, thanks.
Yeah, sure. Matt. Margaret.
Hi. So with the Causal Doctrine example that we talked about with the teacher, I'm thinking back to our paradigm about a situation of self-defense with an excuse versus a justification. Mm-hmm. Is that a useful way for me to think about the Causal Doctrine? Do people ascribe, I know in the discussion and the reading, it sounded like it's not always some people don't even think it's a useful differentiation to make, but I was thinking about somebody mentioned, having a high regard for human life. And like, I personally, if I was in that situation, would want to get in my car, but I don't know if I'd necessarily want to obligate someone to that standard. So I was just wondering if that applied.
I mean, that's an interesting, so I think the distinction is useful as a way of thinking about the rules, but I don't think it's useful as a predictor because it turns out, self-defense is typically thought of as a justification, but in fact, the MPC rules mix up excuse and justification because, they allow exculpation or mitigation to people who unreasonably believe or recklessly believe that self-defense is necessary. That seems like something close to an excuse. In the arguments about the stand your ground laws and the Causal Doctrine, the arguments are always couched as arguments about justification. Who is justified in standing their ground? Who is justified in not having to retreat? So I think the proponents of these exceptions to the duty to retreat think what they're talking about is justification. Now, we might have a different view that, in fact, what they're talking about is excuse, that that person is not, in fact, justified. As, in fact, if we think about many of these cases, anyone who uses force when it is not actually objectively necessary, you might think, is not, in fact, justified. But we're excusing the frailty of human knowledge, meaning your inability in the heat of the moment to figure out whether or not you can get away or not get away. And so we might actually think that there's a lot of excuse work happening in this form, what is formally a justification. And in fact, many self-defense cases, whether or not they involve the Causal Doctrine or not, are in fact, we're giving excuses rather than justifications. Does that help? Yeah. Jennifer.
Just to clarify the MPC rules around retreat, so 3.04 codifies the castle exception in the MPC, but not stand your ground. Stand your ground is purely state statutes.
Yes.
Okay.
MPC does not have stand your ground. Mm-hmm. MPC, I think we can think of it as kind of in middle ground. The traditional common law rule had a pretty expansive duty to retreat. By 1962, we're beginning to see a lot of anxiety in the MPC's rules about how broad the duty to retreat should be, and so its duty to retreat is narrower. And then stand your ground, it's we're just going to abolish it altogether. Okay. But it's common law doctrine. Matt, last question. Matt, sorry.
No, you're good. How does duty of retreat apply to third parties protecting another person?
It's the same. So just like the general rule of self-defense, you just apply to threats to another. The duty to retreat then is, does the other person have a reasonable opportunity to retreat, or can the other person get away with complete safety? We're authorizing force, but we're still thinking about it as, is the person who is the victim or the subject to that force, can they get away? Yeah, thank you. I'll actually say that when I begin class. Okay, it's 11:30, so let's come back. Hi, everyone. So Matt just asked the question about how does the duty to retreat apply in cases where it's defense of others, and it applies in exactly the same way. So you should really think about the defense of others and self-defense as parallel doctrines that apply virtually identically. The only difference is in self-defense cases, you're saying, well, I had to use deadly force to protect against imminent threat of harm to me. And in defense of others, you say, I had to use deadly force in response to a threat of imminent harm against another. But the duty to retreat is, in all cases, analyzed with respect to the person who is the recipient of the unlawful violence. So it's either yourself who has the duty to retreat, or the person on whose behalf you're acting who now has a duty to retreat. Or it's a little hard to think of it as a duty because you're the one invoking the justification, but the justification is unavailable if you're using violence against someone to protect someone who actually could escape. There was no necessity. Okay, so let's pick up where we talked about where we left off with the Causal Doctrine, where there's this question about, although all states recognize some form of the Causal Doctrine, there's a difference of opinion about whether or not the Causal Doctrine applies when one is threatened by a co-occupant. Now, some states say it does not apply because then you both are equally entitled to the house, and then you can be forced out into the mercy of the world. But the majority rule is that it does apply. And the idea here is that you don't want to allow, say, a domestic abuser to force a victim of that unlawful aggression out into the dangerous, out of the potentially only place of safety she or he has, the house. And so proponents of this limitation of the Causal Doctrine argue that it's most important in domestic violence cases. Now, the criticism is that this basically sets up a kind of Wild West situation in the home, where you are empowered to use violence against someone who's using violence against you. And so the home becomes a site where there's just sort of like a duel of violence. But I think the general view is that it seems strange to empower someone to get to use violence against a burglar who enters the home and threatens harm against them, but not to allow them to use violence against intimate harm, when we might think that that's a much more pervasive and serious worry. And so in general, not only in the common law, but in the MPC, the rule is that the Causal Doctrine does not apply does apply even when the threat emanates from a co-occupant. And we can see this if in 3.04 2B21. No. Yes, on top of 1282. The actor is not obligated to retreat from his dwelling or place of work unless he was the initial aggressor, we're about to talk about that, or is assailed in his place of work by another person. I'm not finding it. Oh, I'm so sorry. Yes. The actor is not obligated to return from his dwelling or place of work. So the MPC actually expands the Causal Doctrine to apply not only in the home, but in the place of work, unless you are assailed by someone who is a co-occupant of the workplace. We're not going to worry about that very much because it's such an idiosyncratic rule and it's not reflected in many jurisdictions. We're really just going to worry about the home, that in the majority of states, the Causal Doctrine means that you don't have to leave your house, even if the threat comes from a co-occupant. Okay, so that is the duty of retreat, now humbled and severely limited. Okay, it once was the primary limit on the application of the justification of self-defense or defense of others, but today it no longer is. And today, I think the most important limit on the requirement is the initial aggressor doctrine. Priya, you want to help me with this? So the initial aggressor doctrine was suggested by the Ohio Supreme Court's assertion in Irwin v. State that, let's actually go back to that a true man has no obligation to retreat when faced with an unlawful aggressor, that we're going to figure out the distinction between someone who can invoke the defense and not by thinking about the aggressor or the true man who is without fault. And so the implication here is that an aggressor is not authorized to use the justification. And this is the rule in most jurisdictions, that you lose not only your ability to justify, that you lose your ability to justify force, including deadly force, if you are the person who initially provoked the conflict. You cannot claim the law's protection against violence for violence that you yourself instigated. Now, let's see what this looks like. There's a very significant limitation on the use of the self-defense justification in United States v. Peterson. This is on 925. Okay, Priya, what happens in that case?
Yeah, so this is another jury instruction error case, but the facts of the case are in Keat is the victim. Keat. So Keat and his friends were driving, and then they went into an alley to. It says he has a wrecked car. It didn't really say what happened, but he needed to fix his windshield wipers.
Yeah, I think there's this wrecked car that's just parked in this alley. No one's using it, but it belongs to Peterson, and so and so they come upon it and they think, aha, okay. So then they're fixing the windshield wipers on this car, and Peterson comes out. Are they fixing the windshield wipers? What are they doing with the windshield?
Well, they're removing the windshield wipers.
Very nice of you. Nice way of thinking about it. They're fixing it by removing them from the car, but they're stealing them. Okay.
Right. They're taking them, and so Peterson comes out, sees what's going on. There's a conflict kind of happening there. There's a verbal exchange, and then he goes back into. He goes away and then he comes back into the yard. And at this point, I think that Keat it says alighted from his car. I don't know if he was in the car.
He's in the car, yeah.
He's in the car. And so he's in the car, but then Peterson basically, he returned with a pistol. Yeah. And when he returns, there's another exchange, and Keat goes and gets a wrench from the car. And then, but Peterson has a gun. And so then Peterson, as Keat's approaching him, Peterson shoots him.
Yeah, and Peterson keeps telling him what he's going to do. He says, if you come in here, I will kill you. And then what the hell do you think you're going to do with that? It's this interesting, complicated exchange because the facts of the case suggest that Keat's about to leave when Peterson comes out. And so Peterson's words all seem to be dissuading words, but in fact, they're inciting words, right? They do part of this verbal confrontation that ultimately ends in bloodshed.
Right.
Okay, so Peterson is indicted for second-degree murder and he's convicted of manslaughter, but he appeals, and there's this issue. And what's the issue in the case? What's the legal issue in the case?
Well, it's a question of whether or not there can be a claim of self-defense if there is a self-generated necessity to kill, right? So if he is the one who came back and started the conflict, right, then it's hard to justify whether or not he can kind of support that claim.
Yeah. On the top of 926, the court says the right of homicidal self-defense is granted only to those free from fault in the difficulty. It is denied to slayers who incite the fatal attack, encourage the fatal quarrel, or otherwise promote the necessitous occasion for taking life.
Right.
So the question here is, was he the aggressor in the conflict? Because if he was the aggressor, he completely loses the ability to invoke self-defense, even if we might think in other circumstances, right? Keat is coming up to his house. He's got a weapon. Perhaps we might think this is the kind of imminent threat of death or serious bodily injury that might allow him to invoke the defense. But the question is he an aggressor? And what does it mean to be the aggressor in the conflict, according to the court?
I think here he is the aggressor up until the point where he would have withdrawn, right? Especially since he came back into the alley. Let me see.
Oh, who's the he? Who are we talking about?
Peterson.
Yes.
Yeah.
So how does the court define the to be an aggressor?
Are you talking about the fact that Keat may have been the aggressor initially, but then once Peterson left and then returned, he's the aggressor in that situation?
Well, no, just in general, how do we define aggressor for purposes of the invocation of self-defense? I think the court defines this in the big paragraph sort of at the bottom of 926. So, this is the question about, is Peterson the aggressor? To some degree, it's going to depend upon the legal definition of the term aggressor. What does it mean to be an aggressor in the conflict? What does the court suggest?
I don't know, provoking trouble,
Yeah, it says there appears to be no fixed role in the subject, so let's make one, basically. The cases hold, and we agree that an affirmative unlawful act reasonably calculated to produce an affray foreboding injurious or fatal consequences is an aggression which, unless renounced, nullifies the right of homicidal self-defense. I think that's the key language, but it's not the clearest language, I think, ever written in the history of the English language. It feels very old. Priya, what do you think it means? Something reasonably calculated to produce an affray.
I mean, he had, he reasonably could know that he was going to cause conflict by his actions, right?
Yes. I mean, reasonableness again. Does the defendant specifically have to intend that he's going to provoke a violent reaction?
No, and then there's a discussion in the notes of the scenario of whether if you walk into someone sleeping with your wife, right, whether the act of adultery itself was aggressive or knowing that you were an aggressor. So yeah, I don't know. I don't think so.
I think those note cases are really illuminating of how broad the initial aggressor limitation on the availability of the defense can be. Right. This reasonably calculated language, I want you all to take it very seriously. It is not, in the common law, it is not a subjective intent standard. It has nothing really to do with what the defendant believed or understood what they were doing. It's on an objective standard. Do we think this is the kind of behavior that is likely to result in a response of injurious violence? Is it likely to lead to violence? And so, what do we think? The court here found that a reasonable jury could have concluded that Peterson's actions provoked the encounter, therefore completely losing him the ability to invoke self-defense. And why? Give me the argument for why he was the initial aggressor here.
When he returned to the alley, he came with a gun. He knew that he was coming back with a weapon. He was coming back with.
Okay, but isn't he saying? Basically, don't come. He says, if you come in here, I'll kill you. What are you doing with that? Couldn't we say, come on, he's just trying to prevent Keat from attacking him? Right? He's using a lot of conditional statements. If you do X, I will do Y. If you do this, I will do that.
Right. He's doing those things, though. Like, he's coming with the gun, he's coming at him. He's like, I don't know if he's...
Yeah, I think the court thinks that a reasonable jury could have concluded that he was in fact taunting Keat.
Right.
Okay. That even though he's making conditional statements, even though it would be hard to prove that he specifically intends, right? I think it would be extremely hard to prove beyond a reasonable doubt that he specifically intends for Keat to attack him. All of his articulation or everything he says seems to be contrary to that. It's certainly possible that a jury could conclude that this was the kind of behavior, this taunting, this what are you going to do now kind of language was the kind of thing that was reasonably calculated. It was objectively reasonable to believe it would lead to violence and bloodshed. Now, Priya, according to the court, was Peterson's loss of the justification permanent? Was there anything he could have done to regain it?
If he had, like, in good faith, I think, or if he'd, like, genuinely kind of said, I was just, I'm not, really, I'm trying to back off here. If he said that, I think that could potentially have, but it has to be like a very clear, not only does it have to be clear and like in good faith, I think that it also really has to be communicated to Keat. Like, Keat had to like have known that he was like kind of saying that.
He must make a good faith attempt to withdraw. So
right.
About what the initial aggressive doctrine creates is a kind of dance of violence. So Peterson, the court thinks, was an aggressor here, but he would have regained his right to self-defense if he made a good faith attempt to withdraw.
Right.
At which point he would then, if Keat continues to follow him, then Keat becomes the aggressor, and now Keat loses his right of self-defense, and Peterson has the ability to defend with violence. But what do you think a good faith attempt to withdraw would have looked like?
Yeah, in this situation, I'm not sure. Like, once he comes out with the gun, I don't know, if Keat has the like lug wrench, if, I don't know, he puts down the gun or kind of puts his hands up maybe, or kind of like starts backing and he's like, hey man, like, I don't really mean that. But yeah, I don't know.
Yeah, I think that's great. He had put down the gun and said, hey, I don't mean that. But why might he not have wanted to do that?
Because Keat had a weapon now too. Like, he had like a lug wrench, and so it was escalating.
So note that the initial aggressive doctrine can put aggressors in a really difficult situation, which is the only way in which you regain the ability to invoke self-defense is if you make a good faith effort to withdraw. You show the other person you're no longer aggressing. But of course, they, by this point, are really angry at you because you have aggressed against them. They're responding with the threat of violence. And so it does mean that you might, in fact, be subject to violence against you, and you just have to be open to that possibility. Once you are with fault, once you are an aggressor, the law significantly constrains your ability to use violence in self-defense, at least without facing severe criminal sanctions, unless and until you retreat or make a good faith effort to retreat. And in this context, so that the courts are much less concerned about the ability of you to safely retreat or the risks upon you, because you are the one at fault. Okay, you caused this whole situation to occur, so we're not really going to worry about the burden we're imposing on you. Right. Priya, last question for you. Why is Keat not the aggressor? I mean, Keat's the one who stole the windshield wipers. And I want you all to, there is a possibility, right? If we have a objective reasonableness standard, could a reasonable jury find that stealing something from their car is the kind of behavior that is reasonably likely to lead to a violent reaction?
I think maybe at the start, or like to begin with, but it was almost like when Peterson came back, there was like a second. It's almost like there was another like incident, kind of, or like you look at that separately in and of itself, right?
Yes, I think Keat was the initial aggressor right at the beginning. When he steals the windshield wipers, that is the kind of behavior that a jury could easily conclude is reasonably calculated to lead to a violent affray, right? Like, people, if you're stealing someone's property, this is the kind of behavior that leads people to act angrily. Mm-hmm. But Keat withdraws, all right? He's the aggressor. He loses his right to self-defense, but then he withdraws and then he regains it. And how does he withdraw, Priya? I promise, this is the last question. How does he withdraw?
Like when Keat, how does Keat withdraw?
Yeah.
Like when he's like in the car about to drive away, kind of thing?
Yeah. When he gets in the car and proceeds to drive away, starts to drive away, he's no longer an initial aggressor, because he's making a good faith effort to withdraw from the scene. And so you can see here how Keat becomes the aggressor and then withdraws, and then Peterson becomes the aggressor. And unless and until he withdraws, now Keat is authorized to use violence against Peterson, but Peterson is no longer authorized to use violence against Keat.
And so this is, to be clear, is this the same thing as like present occasion? Like, this is like the new present occasion kind of?
Well, this is under the common law. So we're asking about imminence, but there is this implicit underlying the notion of the aggressor is an idea of an unfolding sequence of events. And so we are thinking about who gains and loses the justification over the sort of this occasion of interaction. But I don't want you to think about a present occasion in the technical term, because that's an MPC term of art that it employs in distinction to the common law. Alex.
Hi, Professor.
Hi. So what if Peterson had chased Keat with a knife, and Keat had then returned with a rifle, say? And, Peterson had never intended to kill Keat. He just intended to scare him off. But Keat now has this very scary semi-automatic revolver. Let's make it even worse. Does Peterson have to take his medicine? Does he, even when faced with overwhelming force, can he not respond? What do you think? Under the logic of the case.
Well, to me, if Peterson's coming after Keat with a knife, that's deadly force, And if it's, I'm imagining you're saying this is in response to the initial theft attempt, right? And so it seems like it's probably the case that Keat never, if nobody's withdrawn, right? If Peterson had the knife in his pocket and was sort of saw, then I think that Keat, it seems, would have never lost his initial aggressor status.
But let's say he did, though. According to the logic of the Peterson case, once you're an initial aggressor and you don't withdraw, can you invoke the justification when you're faced with overwhelming force in response to your aggression?
I don't think so.
No. Okay. The common law rule was the limitation is total. Okay. Even if you become the initial aggressor through some relatively innocuous set of actions that are reasonably calculated to lead to an affray, and the other person responds with overwhelming and unexpected and frightening force, you still have no right to respond, because if you're the aggressor and you're not free from fault, you're with fault, you have no right to the self-defense justification. Now, this doesn't mean that the other person, if they end up using violence against you, isn't subject to criminal prosecution for that violence. But it does mean that under common law, you completely lose your right of self-defense up until the point at which you retreat or make a good faith effort to withdraw, and at which point you regain it. Now, there are some states who have said that when faced with overwhelming force, you have a right to respond, but the majority rule is that the initial aggressor doctrine totally denies the defendant the ability to invoke the self-defense justification. And so let's see what this looks like. Let's look at Allen v. State on 927. Okay, so this is the case in which the defendant, Allen, and her partner quarrel. Her partner, Leathers, grabs her things, gets in a car preparing to leave. Allen pursues her, but then Leathers, the partner, grabs a garden rake and strikes Allen in the face, wounding her. The partner then drives off in her car. Allen pursues her. She catches up with her car, walks towards her partner. They're having this tremendous fight. She sees Leathers approaching her with a rake, at which point she goes to her car and grabs a gun, and she kills her. Now, Allen is convicted of first-degree murder, and she's sentenced to death. This is in Oklahoma. She's ultimately killed. The appeals court upholds the conviction and holds that she's not entitled to invoke self-defense because she provoked the situation. So, Alex, what did she do to provoke the situation?
A lot. I couldn't even take notes on the facts of this case because it was so convoluted. But
because we know that the partner at the sort of in the last set of sequences, it's the partner who approaches her with a rake. All right, so you might think that the victim is the aggressor. So why is she the aggressor?
Right. The Leathers tried to leave, was approached by Allen, actually left, tried to leave in multiple instances and was pursued by Allen, actually left and then was pursued again by Allen. And so there were multiple instances where Leathers was trying to get away, essentially. And so And so Alan was just continuing on. And so when there was, like, she'd already escalated things to a level where there was violence inherent in the confrontation. And so when she was met with, like, the second rake attack, responding with a gun she doesn't have a defense in that case. It's just illegal action against illegal action.
Yeah, I mean, I think the rule to take from this case is that when you pursue the confrontation, when you extend it beyond its otherwise natural life, when you're the one to keep the violence going, you become the aggressor, right? She pursues Leathers. Leathers is withdrawing. Leathers is making a good faith effort to withdraw. She drives away in her car. It is the defendant here who pursues her. In the act of pursuit, that is the act of aggression. Note that the defendant need not do anything violent or criminal in order to qualify as the initial aggressor. It's anything that is reasonably likely to result in a violent confrontation. And in those cases, you become the initial aggressor. And as Priya was suggesting, the common law courts have interpreted the initial aggressor definition very broadly, okay? So Andrews, the United States, on page 928 is the case in which the defendant shows up at the home of his ex-girlfriend, ends up shooting her brother, and the reason that he is found to be the initial aggressor and therefore cannot invoke any self-defense is by showing up, given a bad history, bad blood between him, the brother, and the ex-girlfriend. The court says, given the facts of the case, even though it's not criminal to show up at someone's house, given the facts of the case, it was objectively reasonable that it would lead to violence. And in those cases, you are required by the criminal law to stay away or to take your chances, okay? So this is a way in which the necessity doctrine reemerges in this idea that people should not do anything under the common law that is reasonably likely to result in violence, because if they do, they're not going to be able to invoke the self-defense justification. And this includes things that are otherwise entirely innocuous or non-criminal, so long as, given the facts of the case, it is reasonably likely to result in this kind of violent confrontation. Now, the MPC also has an initial aggressor limitation on the availability of self-defense justification, but it is much narrower. All right, so let's look at 1281. The MPC has a narrower duty to retreat, and it has a narrower initial aggressor doctrine. It has a more expansive justification in these ways for self-defense. So 3.042b1 says you may be justified in the use of deadly force unless the actor, with the purpose of causing death or serious bodily harm, provoke the use of force against himself in the same encounter. Okay? So the MPC requires not an objective reasonableness standard, but a specific intent to cause death or serious bodily harm in order to lose the justification. You must have acted with the purpose of leading to a very violent encounter in order to lose the justification. So, Alex, under the approach of the MPC, in Peterson case, would Peterson have been considered the aggressor?
I think so. Again, like, Peterson's in his home, Keat's leaving, and then Peterson comes out with an unloaded gun and bullets, loads the gun theatrically, in the alleyway while, talking smack, right? And then sort of like approaches Keat and continues to either maintain or escalate the tension as Keat clearly responds. It seems to be provocation.
But do we know that he intended to cause death or serious bodily harm? That is the single inquiry for the MPC. There's plenty of evidence he's trying to scare, intimidate, maybe taunt Keat.
Yeah, just going with the latter, it seems like it could be negligent because he should have known better, and it might even be recklessness. I think knowledge or purpose is a little bit hazier. So even if I wanted to make the case, I think it would be harder to do.
Okay, but no, recklessness or negligence, that is once you got the availability of the defense and you're trying to figure out whether it's a total exculpation or a mitigation. Right. The aggressor doctrine is whether or not you have the defense available at all. And I think under the MPC, in the common law, Peterson loses the the justification because he's the initial aggressor. I think it would be very difficult to show that Peterson is the initial aggressor under the MPC's much narrower rules. And therefore, it's going to be up to the jury to figure out whether he was reckless or negligent in having the belief that force was necessary. But that means the jury is going to be assessing his self-defense claim. Initial aggressor doctrine, in most cases, bars the jury from even having the opportunity to assess the self-defense claim because it is a total limitation on the availability of the defense. And what about the Leathers case? Alex, what do you think? Would the defendant in that case, Allen, have been considered the aggressor under the MPC?
I don't think so. I mean, her behavior doesn't seem like one that's trying to provoke use of force against them. They seem to just be trying to get their partner to come back home with them. And so it seems very different than from what the MPC is listing here.
Yes, I think the Allen case illuminates the very significant difference the most sort of dramatically, because under the common law, even if you're acting in good faith, you're just trying to continue a conversation that's with your ex-partner. You're not really trying to cause any harm. If it does seem reasonably likely to result in violence, you are considered an aggressor. Under the MPC, it is only when you act with the intent of causing serious violence, the intent of causing death or serious bodily injury, that you become the aggressor. So I think there's virtually no way that Allen would have been considered the initial aggressor under the MPC. Now, that doesn't mean she would have gotten the self-defense justification, but it does mean that it would have been available to her and would have been up to a jury to assess whether the necessity and proportionality elements were available. And so the MPC has a much more expansive doctrine of self-defense in this respect because its conception of the initial aggressor doctrine is narrower. And we're out of time, but in the slides I sent, there's a hypo that I think we'll just start with on Monday, which involves whether or not Brenda and her husband can invoke self-defense under the common law, under the MPC, and it'll just be a good recap. So we will start there on Monday. If you have time, take a look at it and see what you think. All right, see you on Monday. And I'll stick around for questions, as I see there are. Bye, everyone. Okay, Nick.
Hi, Professor. So it seems like under the MPC, we can get to a world where no one is the aggressor. Because if what's-his-face comes out and he's talking smack and we have a new encounter and he's talking smack with the gun and he's not the aggressor, and the other guy comes up with the wrench but doesn't intend to kill him, and just has the intent to scare pistol guy back into the house, it sounds like both of them can kill each other and use self-defense as a thing.
There's no necessity that there be an aggressor in a confrontation. I mean, certainly under the MPC, we could have both parties using violence and neither is the aggressor. Even under the common law, I think it's possible to imagine scenarios in which no one is the aggressor. There's no requirement that one person be the aggressor. You could both be responding maybe at the same moment to surprise or not acting in a way that is reasonably likely to result in a fray. Now, it's much more likely under the common law that there is going to be an aggressor and a recipient of aggression, but there's no requirement that you have to find an aggressor. And certainly under the MPC, totally possible that nobody's the aggressor, yes. Matt.
Hi. So, under the common law,
yes,
the Peterson situation in which someone does objectively acts that would be objectively reasonable to instigate violence in anyone.
Yeah.
And the Allen case the Andrews case, where someone does an action that would not reasonably invoke violence in someone, but because of the specific person they aggravated, those are the exact same thing? Because the second one doesn't seem like a totally objective standard to me.
Really? But it's objective given the circumstances. Remember, we're going to personalize through looking at the relationship between the parties, the size, age, race, these external features. All those things you take into account when you're assessing self-defense claims. Now, we don't take into account idiosyncratic beliefs, but we do take into account factual circumstances. Now, some of the difference, though, between, say, the Peterson case and the Allen case is going to determine whether or not it gets sent to the jury or not. Okay, so if there's no possibility that a reasonable jury could find that someone is not the aggressor, they're not even going to hear the self-defense claim, or it's going to be much easier for a court to conclude one way or the other and act as a gatekeeper that the aggressor doctrine prevents the availability of the defense or not. the Andrews case is just going to be much more complicated, and so it's much more likely that it's going to be the jury deciding whether or not this is the kind of thing that is reasonably calculated to lead to an affray. But yes, the initial aggressor doctrine limits the availability of the defense in both circumstances, both when it's sort of in general and when it's case specific, for sure.
But it has to be not just to the specific circumstances, but the specific circumstances as you know them, right? So it can't be like the person working in the kitchen who flicks someone with a dish towel, not realizing that they like that would set them off.
It's an objective standard.
This is why I'm thrown off by it.
I see. So no, I think right. That's an excellent example. I think if you flick the dish towel, that's not going to be considered reasonably calculated to lead to an affray, because there's no, in that case, for example, they'd been friends for a long time. This is the Guthrie case, right? There was no evidence. It wasn't objectively reasonable to imagine that this was the kind of behavior that would lead to that result. It was, in fact, that is exactly the case in which it's unreasonable, because the defendant reacted, or the defendant in that case reacted because of his idiosyncratic subjective beliefs. That's the kind of thing that doesn't factor into the reasonableness inquiry. We're trying to make an objective analysis, but courts think that bad blood between families, a history of bad relationships, is the kind of thing that speaks to the circumstances, not to subjective idiosyncratic beliefs. Again, think the kind of stuff that affects all of us, not the kind of stuff that affects only some of us.
Okay, thank you.
Sure. Spencer.
Thanks. I was just going to ask about reading these cases about the initial aggressor. I was thinking about escalation, or the concept of escalation, but it seems like that's not that. I guess just does the concept of escalation come in, or does that language come in, or does it not?
So in the common law, it's an on-off switch. You're the aggressor, you're not the aggressor. And even if you're the aggressor and then someone else escalates in response to your aggression, you don't regain the right of self-defense. Now, there's a minority of states that allow you to do so. So they have a kind of escalation rule where even if you're the aggressor and the other person escalates, then they become the aggressor and you no longer are the aggressor. But that's very much the minority rule. That is the rule in the MPC, though. So the MPC says even if you're an aggressor, under its very narrow definition of what an initial aggressor is, if you're met with overwhelming and disproportionate force, then you regain your right of self-defense. But that's very much a minority rule. In the context, we don't want to authorize people who act in aggressive ways to invoke the self-defense justification, so you just don't have it at all.
Okay, so the overwhelming and disproportionate force, that would be escalation.
Yes.
Okay.
I think that's what you're talking about, right?
Yeah. That's what Thanks.
Pia.
Hi, Professor. I have a question on the limitations on self-defenses and which are available in which jurisdiction. So is imminence only available in common law? And I guess initial aggressor doctrine is in both MPC and common law?
Yes. Imminence is the rule in the common law. Immediacy on the present occasion is the rule in the MPC. Initial aggressor doctrine is applicable in both, but the way in which courts define the initial aggressor is different. In the common law, it's an objective reasonableness standard. What's the kind of behavior that is reasonably likely to lead to a violent confrontation? But in the MPC, as we were just talking about, you have to have specific intent to cause bodily injury or death.
Thank you.
Sure. All right. I will see you on Monday, and I'll resend the slides. Bye, everyone.